Okay, let's dive straight in. Today, we are undertaking a really sensitive deep dive into a conflict that's shaking the very constitutional core of German democracy.
It really is. We're looking at this foundational tension that has, it's escalated dramatically in recent years.
And this tension pits a core historical duty, something deeply ingrained, against what are supposed to be absolute democratic freedoms.
That's right. Our focus is the constitutional friction that's created by Germany's foundational commitment to the existence and security of Israel. It's known globally by the German term Staatsräson.
Staatsräson, we hear that word a lot.
We do. And it's being pitted against these non-negotiable guarantees of free speech, freedom of assembly, and artistic expression that are, enshrined in the German basic law.
So this isn't just another political debate. What we're talking about here is a profound legal challenge to the very architecture of German democracy itself.
Exactly. It's a system under stress.
Our sources for this analysis are, well, they're crucial for getting to the heart of this. They come primarily from the Verfassungsblatt, which is a top-tier German legal journal.
Which means we're getting meticulously detailed constitutional analysis. These aren't just opinions, they're legal arguments from experts in the field.
And these experts are laying out exactly how the deployment of specific, very expansive definitions of anti-Semitism is leading to something they called Diskursverringung.
A severe narrowing of the space for public discussion. That's the term. And crucially, they're also detailing the specific legal mechanisms that are now being used to push back against that very constriction.
So the mission of this deep dive really is to chart this central conflict. When does criticism of the Israeli government cross the boundary into anti-Semitism, specifically in this unique German legal context?
And what legal tools are authorities actually using to enforce that boundary? We have to explore the severe complexity this creates for everyone living in Germany.
Particularly, I imagine, for those who have alternative perspectives rooted in the Middle East, people like Palestinians.
Yes, and also, just as importantly, Jewish individuals in Germany who hold strong critical views of the state of Israel or its current government's policies.
It's a situation where, historical guilt and contemporary democratic ideals are in a direct and seemingly unavoidable conflict.
That's the heart of it.
Okay, let's unpack that core philosophical and political mandate first. Staatsräson. We have to understand the sheer weight of this term. Germany's commitment to Israel isn't like its alliance with, say, France or the U.S.
Not even close. It's viewed as a foundational, almost non-negotiable moral obligation. And it stems directly, of course, from the Holocaust.
And our sources are very clear on this part. They say the dual goals tied to this commitment, ensuring Israel's security and determinedly combating anti-Semitism, are fundamentally necessary.
And welcomed. That's a key point, especially given the rising security risks in the region and the, frankly, worrying increase in anti-Semitic crimes happening inside Germany.
So that acknowledgement of necessity is critical. No one in this legal analysis is arguing against the need to fight anti-Semitism or to support Israel's security.
No, absolutely not. The problem, as the sources frame it, lies entirely in the interpretation and the application of this Staatsräson in our current political climate.
The how, not the what.
Precisely. The legal experts argue that this specific, very rigid interpretation is now directly leading to what they describe as real restrictions on basic freedoms.
So we're talking about freedom of assembly, freedom of opinion, art, science, the big ones.
All of them. Versammlungs, Meinungs, Kunst und Wissenschaftsfreiheit, the pillars of a free society.
That is just a staggering legal paradox when you think about it. The commitment designed to ensure the safety and existence of Jewish life in the state of Israel is now arguably restricting the very democratic rights that are guaranteed to all citizens under German law.
It is, and the sources dig into the philosophical justification for this contradiction.
How do they justify it?
It's deeply, deeply rooted in German history. This commitment is tied intrinsically to the democratic self-conception of the Federal Republic. The source argues that in light of the unspeakable Nazi mass crimes, Jewish life and the right for the state of Israel to exist are not just political preferences.
They're more than that.
They are central, specially protected elements of Germany's entire post-war identity. And that is why the state feels compelled to prioritize this commitment, even when it rubs up against constitutional freedoms that are usually considered absolute.
So, in essence, the modern democratic state of Germany is defined in large part by its historical trauma, and that trauma mandates a specific political position today.
Precisely. And this is exactly where that Diskursverengdung, the narrowing of discourse, really begins.
Because any criticism that even seems to undermine that mandate is immediately viewed through this lens of historical betrayal.
Not just as standard political dissent, it's seen as something much worse. And we saw a powerful, very tangible example of this philosophical justification at work recently. It involved one of Germany's most influential public intellectuals, Jürgen Habermas.
Right, let's talk about Habermas and his co-signers. Because after recent events, they stepped right into the middle of this political fray, condemning a certain line of criticism against Israel's military actions.
They did. They publicly drew a very clear line in the sand. They asserted that certain discussions, specifically any talk of genocidal intentions regarding Israel's military action, had crossed the boundary. In their view, it fully constituted anti-Semitism.
And here is the crucial point for our analysis. They justified this stance not primarily based on military facts or legal evidence, but on what?
Explicitly on the basis of German historical memory. They articulated that Germany's political culture, which was forged in direct response to the NS mass crimes, necessitates this protective stance towards Israel.
So in their view, German history itself compels this specific, very restrictive interpretation of what constitutes acceptable criticism.
Exactly. And this is where that philosophical position instantly creates constitutional friction. Because, as our sources remind us, you have highly respected legal experts, human rights organizations, and genocide researchers who are engaged in that complex, difficult legal and academic discussion.
Right, they're debating concepts like genocidal intentions in relation to contemporary military actions all over the world, often citing international law and filings in international courts.
Exactly. So when a figure with the stature of Habermas deploys the full weight of German historical memory to just dismiss that entire line of inquiry as anti-Semitism, it effectively works to shut down a legitimate academic and legal debate.
A debate that is robustly taking place everywhere else.
Everywhere else. It shows how Staatsräson functions as kind of preemptive legal and moral shield. It enables the state and quasi-state actors to enforce this narrowing of the discursive space, even against legitimate academic freedom.
It reframes complex political criticism as a simple moral failure.
That's a perfect way to put it.
So if that is the problem, this conflict between historical duty and contemporary rights, what is the proposed legal solution? The source material suggests it requires something fundamental, an evolution in Germany's remembrance culture, its Erinnerungskultur.
This is, I think, the most profound legal recommendation in the entire analysis. The argument is that to alleviate this constitutional tension and to protect fundamental rights, Germany cannot maintain a static, singular view of its historical reckoning.
The culture of remembrance has to evolve. It has to reflect the cascading consequences of the 20th century.
Yes, and this evolution, they argue, must include a crucial and often avoided step.
Which is acknowledging the fate of the Palestinians.
Precisely. The source insists that the only way to genuinely mitigate this legal tension between Staatsräson and fundamental rights is to formally acknowledge the fate of the Palestinians and their ongoing dispossession, the Crackdown, as an indirect consequence of the Holocaust.
Wow, that isn't just a political suggestion. That is presented as a legal necessity for the coherence of the German constitutional state.
It is a staggering legal claim.
So how do the sources connect the Holocaust to Palestinian dispossession in a way that creates a legal and moral framework that demands state acknowledgement?
Well, the rationale is, as you can imagine, deeply complex. It centers on causality and responsibility. The source argues that the establishment of the State of Israel was fundamentally, historically, and politically linked to the need for a Jewish safe haven following Germany's unprecedented crimes.
Okay, that's the direct link.
Right, but the Entrechtung, the flight and expulsion, the Nakba, which accompanied the state's founding, is therefore seen as a direct consequence of a historical chain reaction that was initiated by Germany.
So in this view, German historical responsibility doesn't just stop when it recognizes Israel's right to exist.
It can't. It must extend to recognizing the historical, moral, and political damage done to a third party, the Palestinians, as a result of the solution that was necessitated by the Holocaust.
So, if the German state were to recognize this indirect consequence, it would mean their historical duty, the Staatsräson actually grows. It wouldn't mean abandoning the commitment to Israel.
Not at all. It would mean expanding it to include a universal principle of non-dispossession.
So it transforms Staatsräson from an exclusive commitment to a more inclusive one.
That is the essence of the proposed evolution. The argument is that if the foundational principle is never again, then that principle has to be applied universally. A truly evolved Erinnerungskultur would demand a dual responsibility.
Okay, what would that look like?
Ensuring the safety of Jewish life in Israel, while simultaneously committing to preventing the perpetuation of the statelessness and dispossession that resulted from that post-Holocaust geopolitical arrangement.
That shift would fundamentally change the legal ground. It would demand recognition of Palestinian human rights as a co-equal moral derivative of Germany's historical duty.
And in doing so, it relieves the pressure on fundamental rights. It makes the commitment less about rubber-stamping specific government policy and more about universal human security.
That would certainly create a much broader and therefore less restrictive legal basis for discourse. It allows for criticism of the Antragtung without that criticism automatically being labeled as questioning Israel's fundamental existence.
And this brings us directly to the primary instrument being used today to enforce that narrow interpretation of Staatsräson.
The working definition of anti-Semitism developed by the International Holocaust Remembrance Association, the IHRA.
The IHRA definition, yes.
Let's be really clear about its origin versus how it's being used now. The IHRA definition was never intended to be a binding piece of legislation, was it?
That is absolutely crucial. It was intended merely as a non-legally binding tool, something for monitoring anti-Semitism trends across different countries.
It was adopted in a Bundestag resolution in 2019, became central to Germany's national strategy against anti-Semitism, NACIS. The problem begins when this monitoring tool gets repurposed.
And the sources are completely unequivocal on this point. The IHRA definition is criticized precisely because it is unsuitable for its current extensive application as a regulatory instrument.
Okay, so why does that shift from monitoring to regulation? Why does that break the legal framework?
Well, think of it this way. A thermometer is an excellent tool for monitoring the temperature in a room.
Sure.
But you wouldn't use that same thermometer as the thermostat to actually regulate the heat flow in a complicated building. When a concept like anti-Semitism is used to regulate speech or assembly or research funding or artistic grants, it has to be legally precise and non-contested.
And the definition of anti-Semitism is not that.
It is a highly contested academic and public question.
Yeah.
Especially where it intersects with criticism of Israeli policy. So the state is trying to regulate democratic life using a definition that simply lacks the required legal certainty.
And we see overwhelming evidence of this expert disagreement. The sources emphasize that many established anti-Semitism researchers and legal scholars flat out reject the IHRA definition.
They do, precisely because its scope is too broad and ambiguous when you apply it to Israel-related criticism. By adopting it as a regulatory mandate, the German state is essentially picking one side in a very robust, ongoing academic debate and then forcing that position onto public life.
What are the academically recognized alternatives that scholars are promoting, the ones that show this field is far from settled?
There are several major alternatives, which really demonstrates that the intellectual community rejects this idea of a single monolithic definition. The sources mention the Jerusalem Declaration on Anti-Semitism.
Right. That was signed by hundreds of respected scholars,
including many Israeli, American, and German experts. And it aims to preserve the definition of anti-Semitism while explicitly protecting non-anti-Semitic criticism of Israel. That includes things like opposition to Zionism or support for Palestinian rights.
And there's another one, the Nexus document.
Yes, drafted by U.S. scholars. It offers similar detailed guidelines for distinguishing legitimate political dissent from actual anti-Semitism.
So the very existence of these highly credible scholarly alternatives really undercuts the legal authority of the IHRA definition to be mandated by the state.
Absolutely. And the sources also highlight international precedent for caution. The U.S. national strategy to counter anti-Semitism, for example, explicitly avoids adopting a single definition.
Why?
Because it recognizes the dangers inherent in legally enforcing a contested concept. So Germany's choice to aggressively deploy the IHRA definition, well, it appears increasingly isolated in the international legal community.
Okay, let's move to the practical consequences of this. How does this controversial definition create concrete legal ambiguity when it's used by governmental bodies?
So when state bodies or quasi-state institutions like universities or cultural foundations apply the IHRA, they immediately run into the problem of distinguishing between legitimate, necessary criticism of the Israeli government.
Which the sources pointedly describe as being, in parts, right-wing extremist.
An important detail, yes. Distinguishing that from actual anti-Semitism aimed at Jews. And because the German state operates under this imperative of Staatsräson, authorities have a structural historical incentive to, well, to err on the side of caution.
Which means they will always tend toward a strict and expansive interpretation.
Correct. The sources observe a very clear tendency toward a strict, expansive, and often uncritical interpretation of IHRA by these public bodies. And this tendency directly results in that narrowing of the discursive space, the Diskursverringung.
And why is that the direct result?
Because when political criticism becomes inherently risky, when it carries the threat of sanction or losing your funding or public shaming under the banner of anti-Semitism, most people, whether they're artists or academics or activists, will simply choose silence or self-censorship.
And this is where the application becomes legally problematic in the most fundamental way, in the allocation of public resources, things like research and arts funding.
Indeed. Making the IHRA definition the mandatory basis for funding guidelines is legally problematic on multiple fronts, but particularly concerning academic freedom, Wissenschaftsfreiheit.
Because the state cannot legally prescribe a specific definition as a condition for funding when that definition is itself the subject of intense, ongoing scholarly debate.
Exactly. If the state mandates the IHRA definition, it is essentially dictating the conclusion of academic research.
Yeah.
Especially in fields that study the Middle East conflict, human rights, or post-colonialism.
So the state is effectively saying, we will only fund your research if you start with the conclusion that our chosen definition of anti-Semitism is the correct one, which is the absolute antithesis of academic freedom.
It completely undermines the freedom of inquiry. And furthermore, this expansive use of IHRA deeply infringes upon the freedom of art, Kunstfreiheit. The source material warns this extensive application risks triggering widespread self-censorship. Artists realize that if they touch on sensitive geopolitical topics, or if they criticize Israel in a way that might fall under that expansive IHRA umbrella, they risk being defunded or having their exhibitions canceled.
Which forces cultural producers to adhere to an externally imposed political consensus, that narrow interpretation of Staatsräson, just to receive public support. That amounts to indirect state censorship.
It effectively weaponizes bureaucratic requirements, like funding applications and institutional guidelines, to achieve a political uniformity that the state could never enforce through direct legislation without violating the basic law.
That is the core legal maneuver we are witnessing. The IHRA definition transforms from a simple monitoring tool into a bureaucratic mechanism of political compliance.
And it intervenes where the fight against actual criminal anti-Semitism is not necessary, but where political or artistic dissent is simply being suppressed under administrative cover.
So now we turn to the critical countermechanisms, the constitutional freedoms themselves, which are currently being mobilized to challenge this creeping regulatory overreach. This is the battle being fought on the high ground of the basic law.
Exactly.
And we first have to understand the hierarchy of freedoms in Germany. You mentioned Meinungsfreiheit, freedom of opinion, and Kunstfreiheit, freedom of art. They are not protected equally, are they?
They are not. Freedom of opinion is robust, of course, but it finds its limits in general laws. Things like laws protecting personal honor or preventing incitement to hatred.
But the freedom of art is different.
The freedom of art, which is enshrined in Article 5.3 of the Basic Law, enjoys a much, much stronger level of protection. The constitutional text dictates that Kunstfreiheit finds its limits only in the Constitution itself.
Which means only the most severe constitutional interests or conflicts can possibly limit it. The standard for intervention is incredibly high.
Incredibly high.
So if that bar for intervention is so high, how does the state even attempt to interfere with art or academic inquiry? And more importantly, what stops them?
What stops them is a foundational principle of post-war German democracy. It's the prohibition of an unconstitutional scrutiny of beliefs, which is known as Gesinnungsüberprüfung.
A term born directly out of the historical memory of the Nazi state.
Absolutely. Where citizens were persecuted not for their actions, but for their thoughts, the political loyalties, their inherent beliefs. Gesinnungsüberprüfung is the legal firewall against the state, demanding a political loyalty test or a confession.
So the Constitution fundamentally prevents the state from doing this.
It does. The source material emphasizes this over and over. State intervention is only permissible when speech or actions abandon the purely intellectual or expressive sphere and cross a clear line into criminal legal violations.
Things like incitement or a recognizable threat.
Right. You cannot be punished or defunded or denied a venue merely because your political attitude or your underlying belief is deemed incompatible with Staatsräson.
That distinction is paramount. It means that simply violating an expansive interpretation of the IHRA definition cannot be the basis for state sanction unless that violation also constitutes a clear criminal act.
Precisely. And we have a powerful real-world example of the judiciary acting as the ultimate check against this kind of political overreach. It's the Documenta 15 controversy in Kassel.
Right. This was a major international art exhibition. It faced intense scrutiny and accusations of anti-Semitism relating to specific artworks. The Kassel Public Prosecutor's Office had to investigate whether these allegations amounted to a criminal breach.
They did. And their decision was critical.
And what was the outcome of that official investigation in light of the IHRA definition?
The Public Prosecutor's Office decided not to pursue the anti-Semitism allegations. The judiciary found that while the art may have been highly controversial, perhaps offensive to many, and possibly violated the state body's interpretation of the IHRA definition,
It didn't meet the threshold.
it did not meet the very high threshold of a criminal law violation that is necessary to limit Kunstfreiheit.
So the state's own legal mechanism refused to intervene.
Yes, and the source uses this case to prove that intervention based solely on a subjective, expansive interpretation of the IHRA definition pushed by political or cultural bodies is constitutionally impossible in Germany.
If the prosecutor had proceeded based purely on the political controversy, what would that have meant?
The source argues they would have fundamentally violated the prohibition against Gesinnungsüberprüfung. The Documenta 15 decisions serve as a key legal precedent. It demonstrates that the state cannot force political compliance or punish underlying beliefs under the guise of fighting anti-Semitism, unless criminal law is clearly and unambiguously broken.
Now, moving from the arts to academia, the same pressure manifests through institutional alignment, specifically via the University Rectors Conference, the HRK.
The HRK is the Association of Universities and Higher Education Institutions in Germany. They carry immense quasi-state authority and influence over university policy and funding structures.
And they have publicly supported applying the IHRA definition within universities.
They have, effectively using their institutional weight to normalize its use across research and teaching.
What specific fields are most vulnerable when a definition like IHRA is institutionally mandated in this way?
The sources explicitly highlight the academic freedom of researchers in two specific disciplines: postcolonialism and Middle East studies.
Why them in particular?
Because these fields, by their very nature, critically examine power structures, historical narratives of conflict, Israeli policy, and international law. By institutionalizing the IHRA definition, the HRK creates a chilling effect.
A chilling effect where research into issues like land dispossession or military occupation or contested definitions of statehood immediately risks being flagged as potentially anti-Semitic.
And this isn't just about a label, this is about job security. It's about the ability to even conduct research. If a professor or a researcher is forced to use a specific, politically sanctioned definition of anti-Semitism, it restricts their methodological freedom. If they choose to use the Jerusalem Declaration instead, or if their research findings challenge the notion that certain criticisms of the Israeli state are inherently anti-Semitic, they face the threat of defunding.
Or non-renewal of contracts or disciplinary action enforced by the HRK's institutional alignment.
So self-censorship becomes the rational choice, and scholarly debate on these contested definitions is killed, which served the goal of Diskursverringung perfectly.
This really shows how the constitutional fight is no longer abstract. It directly impacts whether essential, critical analysis of geopolitical history can even be performed within German academic institutions.
The constitutional tension we're discussing has profound real-world consequences, particularly for Germany's diverse communities, people who hold perspectives rooted outside of the traditional German Erinnerungskultur.
And following recent major geopolitical events, especially the conflicts that escalated after October 7th, we saw immediate political demands placed upon specific communities within Germany.
We certainly did. Prominent politicians demanded that Muslims in Germany publicly and explicitly take a strict stance against anti-Semitism.
And these demands were often accompanied by suggestions that German citizenship should potentially be dependent on such a committed public declaration of loyalty.
Or that residency status should be reviewed. It seems to echo the Gesinnungsüberprüfung issue we just discussed, demanding political loyalty as a condition of participation.
It absolutely does, but it's directed at a specific demographic. The source material describes this practice as externalization.
And suggest it is potentially racist because it results in these sweeping generalizations about entire communities based on their assumed background or religion. It fundamentally ignores the fact that immigrant communities, particularly those from the Middle East, possess different historical memory cultures.
Cultures where the processing of the specific legacy of the Nazi crimes is simply not the central focus it is for the German state.
Exactly. And this demand creates an insurmountable dilemma for Palestinians living in Germany.
The dilemma is acute. The source highlights that Palestinians in Germany cannot be expected to automatically identify with the German Staatsräson responsibility toward Israel.
Their collective memory is profoundly shaped by the flight, the expulsion, the loss of homeland, the Nakba. It's directly linked to the state's founding, an event that occurred decades before many of them ever arrived in Germany.
So their experience is one of historical displacement, which is separate from the German perpetration of the Holocaust.
And to force them to adopt the German Staatsräson perspective without acknowledging their own historical reality stemming from the same geopolitical event is, well, the sources say it's profoundly unjust and contributes to their ongoing marginalization within German public discourse.
It sets up a conflict where recognizing your own collective history risks violating the state's interpretation of its core historical duty.
Exactly. The German state is essentially asking these citizens and residents to disavow or sideline their own historical narrative to align with a singular, politically mandated historical memory. This externalization contributes significantly to the Diskursverringerung.
It makes it impossible for a large, affected demographic to voice their experience or criticism without facing sanctions or accusations of anti-Semitism.
Now let's explore the most severe legal implication here, the conflict with international refugee law.
This is perhaps the most serious consequence of the IHRA definition's overreach.
It is. When the IHRA definition is applied with its expansive scope as a regulatory instrument, it risks classifying political statements that are otherwise compatible with internationally accepted human rights standards as anti-Semitic crimes.
And why does this immediately put refugees at risk?
Because of the Geneva Refugee Convention, the GFK. If a person applying for asylum is deemed to have committed an anti-Semitic crime under this broad German interpretation, they could face exclusion from refugee status under Article 1 FB of the GFK.
And that article allows exclusion only for individuals who have committed a grave non-political crime.
Right. So we need to understand the difference between a political statement and a grave non-political crime. The UN High Commissioner for Refugees, the UNHCR, their guidelines are very clear.
What do they say?
A crime is considered political unless it causes extreme human suffering, or its political goal is fundamentally incompatible with the exercise of human rights.
So the source material warns that while calling for the annihilation of Jews is unequivocally incompatible with human rights and warrants exclusion.
Of course, but the expansive IHRA definition risks capturing legitimate, nonviolent political statements. Things like strongly worded condemnations of illegal settlements or calls for an end to the occupation or even support for a single democratic state solution.
Which are all compatible with international human rights law.
Let's create a concrete hypothetical scenario to illustrate this. Let's say a refugee claimant has a history of publishing articles that strongly condemn the Israeli government's policies, maybe using language like apartheid or calling for a full boycott of Israeli goods. But there is zero evidence of violence or incitement against Jewish people.
Okay.
Under a narrow constitutional interpretation, those statements are legitimate, nonviolent political expressions protected by freedom of opinion and compatible with international human rights.
But under the expansive, rigid interpretation of the IHRA definition often deployed by German authorities.
Some of those statements might be flagged as questioning Israel's legitimacy or applying double standards, and therefore labeled anti-Semitic.
And if they are labeled as an anti-Semitic crime, the refugee could then be accused of having committed a grave non-political crime.
And the source warns that denying refugee status on the basis of political statements that adhere to international human rights standards would be a clear breach of the GFK and contrary to international law.
That is a stark demonstration of how the German state's unique political commitment, one rigidly applied, can undermine its obligations under universal human rights and international law.
It shows the severe pressure the Staatsräson is exerting on the entire legal system, creating conflict across the board, from academic funding all the way to the protection of asylum seekers.
Finally, let's turn to the complex issue of Jewish representation in Germany, which is often rendered invisible by the state's singular focus on Israel's security as a monolithic commitment.
The public debate surrounding those alternative definitions, the Jerusalem Declaration, the Nexus document, is profoundly significant here.
Because they're supported by hundreds of scholars, many whom are Israeli or Jewish.
Exactly. Their very existence underscores a fundamental truth. There is no single, unified, monolithic Jewish perspective on Israel. Jewish identity is not synonymous with the state of Israel, let alone the policies of its current government.
Yet the German state, in its pursuit of fulfilling its Staatsräson, often treats its commitment to Israel as equivalent to an uncritical commitment to the policies of the sitting Israeli government.
And that is the crucial political simplification that the legal sources object to. This simplification excludes a vast amount of legitimate internal dissent. This body of competing definitions highlights that many individuals, including German Jewish citizens and residents, may profoundly disagree with the specific policies of the current Israeli government.
And by extension, they may feel entirely unrepresented by the rigid, expansive German interpretation of Staatsräson.
Which means broadening the discourse. The fight against Diskursverungung is actually essential for protecting the democratic space for Jewish dissent within Germany itself.
That's a vital point. The broadening of discourse is a necessity for protecting the pluralism of all of German society.
Absolutely. When the state forces an association between Jewish identity and a singular political position on Israel, it paradoxically harms the very community it seeks to protect. It stifles internal debate, and it alienates those who demand the right to criticize Israeli policy from a position of Jewish responsibility and conscience.
So the constitutional fight against the overreach of the IHRA definition is also a fight for the intellectual and political freedom of German Jews, too.
It has to be.
Here's where it gets really interesting then. What we have uncovered is a legal system struggling to balance its most profound historical duty, the Staatsräson, with the core tenets of contemporary democratic rights.
And the very tool meant to combat anti-Semitism, the IHRA definition, is, in the view of the sources, being bureaucratically deployed by the state to police political boundaries, academic freedom, and funding decisions.
Leading to a profound and chilling narrowing of discourse that affects everyone, but especially vulnerable communities.
And if we connect this to the bigger picture, the crisis isn't merely political, it's systemic. It's about the very mechanisms of law funding criteria, academic endorsements, institutional guidelines, refugee protections being corrupted or warped by a rigid, undifferentiated interpretation of a political commitment.
That constitutional principle against the Gesinnungsüberprüfung, the state's inability to demand loyalty or scrutinize beliefs, is being eroded by this intense pressure to declare explicit political loyalty to the German conception of Staatsräson.
And this undermines the democratic foundation that was built on the ashes of totalitarianism.
We noted the source material's bold and controversial call for a truly evolved German remembrance culture, one that acknowledges the dispossession of Palestinians as an indirect consequence of the Holocaust. So here's the thought to leave you with. If the core lesson Germany took from its historical tragedy is never again,
then must German policy not only ensure the security of Jewish life and the state of Israel, but also actively seek to prevent the perpetuation of statelessness and dispossession, thereby embracing a universal rather than an exclusive application of that principle.
this is the ultimate legal and moral trajectory the sources propose. If Germany's foundational constitutional identity is rooted in that historical lesson, then the legal interpretation of Staatsräson must eventually account for all the cascading consequences of that history.
The challenge for German democracy, then, is to move from a historical mandate rooted in singular protection to a universal principle of justice that simultaneously ensures Jewish security and advocates for the universal human rights of Palestinians, recognizing that these two imperatives, though politically difficult, are fundamentally linked in achieving long-term constitutional and democratic coherence.